Good morning, everyone. Thank you for joining. My name is Deandra Coleman, and I'm with the Virginia SBDC Network. For those of you that are not familiar with our organization, the Virginia SBDC is a partnership program between the U.S. Small Business Administration, George Mason University, and local host institutions throughout Virginia. With 27 locations across the Commonwealth, we provide training and technical assistance to small businesses in their local communities. Our one-on-one consulting services are available at no charge. Today's webinar, Trademark Basics, is presented by the Virginia SBDC in collaboration with the United States Patent and Trademark Office, and it is the last in a series of 4 webinars covering patents, trademarks, copyrights, and trade secrets. Before we get started, I just want to mention a couple of housekeeping items. We are recording today's presentation and it will be posted on our website, virginiaspdc.org. Due to the large number of participants in today's webinar, everyone's microphone is muted. If you have questions during the presentation, you can type those into the Q&A box, and time allowing, our presenter will answer them at the end of the presentation. Today's presentation will be given by Craig Morris. Mr. Morris works with the Office of the Commissioner for Trademarks in the United States Patent and Trademark Office. Currently, he is the managing attorney for Trademark Educational Outreach, focusing on increased educational activities in the area of trademark fundamentals. Over a 37-year career, he has gained exposure to a full range of trademark-related issues. And now I will go ahead and turn it over to Craig.
Thank you very much. I always like to set the stage for the program this morning with the following. An executive of the Coca-Cola Company was once asked, consider your company's most valuable asset to be. He said, without question, it is our registered trademark. We could lose everything that we have as a business and be able to build again as long as we still had that registered mark. One of my objectives for the program this morning is to help make you view a trademark in that way, a very valuable business asset. Now I'm going to go off camera to save some bandwidth, and we'll go to the next slide. So these are going to be the discussion topics for this morning, and then hopefully at the end there will be enough time to field some of your questions. Next. So the very first discussion topic is just definitional, going through the types of marks. Next. So here is the classic definition of a trademark. And the two very important buzzwords there are identifies and distinguishes. Next. Okay, so for trademark, it specifically protects goods or products, but what if you don't have goods? Instead, you have a service. Well, then technically you have what is known as a service mark. So trademark for goods, service mark for services. Now, you've probably seen these symbols, the TM, the SM, the R in a circle. All of you today could start using either the TM or the SM, even if you've never applied to seek federal registration, because you have adopted that as your mark. The only thing you're not to do is use the R in a circle unless and until the USPTO has granted a federal registration. Now, it's never required that you use these symbols, but they're helpful because they do put the public on notice you're actually claiming ownership rights in this specific mark. Next. Now, to give the full breadth of background here, these are all what we call intellectual property. There's trademarks, but then there's a patent, a copyright, or a trade secret. Again, all considered different types of intellectual property. But again, today we're obviously just focusing on trademarks. Next. Now, there are what we call the traditional types of marks. The first being a word mark, or a slogan. Always remember that a slogan is simply a longer word mark. Now, sometimes it can be presented in a very particular stylization. We're all familiar with that display of Coca-Cola. If the mark consists of both wording and a design element, that's what we call a composite mark. Or perhaps there's no wording at all, it's simply an overall design mark. Again, these are what we call the traditional types of marks. But there are others, next slide, that are non-traditional. And these are all examples of the non-traditional types of marks. Bottom line, simply remember that anything that might function as a source identifier could be considered a trademark and may in fact be eligible for federal registration. Next. Now, sometimes people will say, well, I don't think I need a trademark because I already have my domain name registered. Or I don't need this because I have my business name registered. Well, those are obviously important considerations in today's marketplace to have a domain name and a business name, but they simply do not give the same rights and protection as a trademark. Next. So what is a domain name? Well, it's a URL, it's a website address. And there at the top, that is used as simply a domain name. But then below that, circled, flycheap.com, that is being presented in the manner of an actual mark. Similarly, next slide. A business name. Well, in order to do business in any state, you have to register that specific name with the particular state. Again, that is simply saying that you're using that name as your business name. Again, there's a possibility that the same wording could be used in the manner of a mark. So in the lower right corner here, that is simply used as a business name, presenting the name and the physical address of the business. Contrasted with what is circled in the upper left, there, that same wording is being used in the manner of a mark. Next. Now we're going to talk about the benefits of federal registration. Next. Well, to understand the benefits of federal registration, you first must understand that there are rights that flow not from registration, but rather from the common law. A common law mark is one that it is used in commerce, but it simply, for whatever reason, is not registered. Now, one of the important considerations with common law is that the rights are specifically limited to the geographic area where the marks are being used. A logical question, though, is what happens when the use is through the internet? It's displayed on a website. Well, if you can establish that, in fact, the website is reaching a broad range of customers in different geographic locations, in California, in Minnesota, Florida, Maine, for example, then an argument can be made that the common law rights actually are very broad. Now, if they simply are used to support a local business, the website only is attracting customers from a very small geographic area, well, then again, the common law rights are going to be limited. Now, the symbols, same symbols we saw before, the TM, the SM, their use is optional, but again, you're entitled to use it if you're using the mark in commerce, but you'll never be able to use the R in a circle. Again, that's dedicated only to a federal registration. The last point here is very, very important, that under US law, the first user of the mark is going to have superior rights, even above registration rights. That always confuses people. You could actually go through the registration process and be successful at the USPTO, but then get a cease and desist letter. And you think, well, how is that possible? I have a federal registration. Well, someone may be claiming that they have superior rights, again, because the first user will always have superior rights. Next. But again, there are rights that flow from registration that never flow from the common law. The first being that presumption that you're the rightful owner in all 50 states and our US territories. But remember, it doesn't extend to other countries. If you want protection in another country, you have to deal with the specific laws and regulations and the office of that specific country. Gives you the right to use the registration symbol. You automatically will be listed in the USPTO database. Well, why is this important? Well, if someone knows enough to search the USPTO database, they're going to find your listing there. That may be enough for them to say, gee, someone already has the mark registered that I want it. I guess I should adopt a different mark. You may not even be aware of that person. You didn't have to do anything. they have made the decision to change their mark because they found your listing within our database. Next. Gives you legal rights relative to proceedings in a federal court. The next point there, U.S. Customs and Border Protection, this is very important if you're aware of counterfeit goods possibly coming into this country. You must record your federal registration with U.S. Customs and Border Protection in order for them to stop the infringing goods from coming in. They simply are not able to do anything at all if they don't have a copy of your recorded registration. And the last point there, again, I mentioned other countries. Well, you could use your federal registration as a basis for filing under an international provision known as the Madrid Protocol. Important buzzwords there. If you're interested in protection through the protocol, use that as the search term on the USPTO website, Madrid Protocol, for more information. Next. Now we're going to turn to considerations that are important when selecting a mark. Next. We need to be aware of the following challenges, that not every mark is going to be registrable. Some people think, well, I simply pay my money and I'm going to get this. Well, again, you're only applying. You're not trying to buy the mark. Be aware that any filing fee, it's not going to be refundable. But with that said, do remember that it is the USPTO mission to register any mark that is eligible for registration. And we're going to try to help you in any way we can, as long as you do the proper steps at the beginning. Finally, remember that not necessarily every mark will be enforceable. Again, going back to that earlier point, even if the mark is registered, there could always be someone who's going to assert superior rights under the common law. Next. So one of the first things to be concerned about when adopting a mark is that you're avoiding what is known as a likelihood of confusion. That's confusion as to the actual source of the goods or services. And we look at two very specific things. Are the marks confusingly similar? And the second part, and a lot of people for some reason forget about this second part of the test, you always have to look to see whether the goods and services are somehow related. If they are not related, even if the marks are identical, there is no likelihood of confusion. So for example, Dove for a bar of soap and Dove for an ice cream bar, although the trademark Dove identical there is no likelihood of confusion because a bar of soap and an ice cream bar simply are not related. Next. And here I have some other examples. X-seed for agricultural seeds and X-seed for live plants. Again, they are considered to be similar because they are phonetically equivalent. Even though they don't look the same, X-seed, they sound the same. Then we have to look at the second part of the test. Agricultural seeds and live plants, yes, they are related. So there would overall be a likelihood of confusion. Next, you might wonder, well, why do we have this example, Lupo for pants and Wolf for shirts? Well, under what is known as the doctrine of foreign equivalence, even though they are in different languages, because Lupo translates from the Italian into English as wolf, the marks are considered similar. Here, pants and shirts, clearly related goods, so overall, a likelihood of confusion. And then the bottom there, the point that I always already considered, that identical marks can coexist where the goods or services simply are not related. Next. Now, what's the step to take to avoid a likelihood of confusion? Well, you're going to have to do a search. First off, you could do your own search using the database of the USPTO. That's through a system known as TESS, Trademark Electronic Search System. Now, TESS only contains the records of registrations and applications. You will not find anything related to the common law. And because you want to be aware of all possible problems, you should also do an internet search. So you're doing a search using the same test is there anyone out there using a similar mark for related goods or services? Now, if you find someone using a similar mark for related goods or services, then you have to become a detective. You have to find out when they actually first used the mark. Because again, if they used the mark before you did, they will always have superior common law rights. Next. Now, another option for searching is to actually hire a private attorney or a search firm. You may realize, I'm not a proficient searcher and I want to make sure to avoid a likelihood of confusion. So I want to hire someone who has more expertise. And so what they're able to do is a full clearance search, searching all of the things listed there. But before hiring a private attorney or a search firm, I always recommend that at a minimum, you at least try to do your own search through tests. Why is that? Well, even if you don't perform what I would call a great search, even if your search only uncovers one possible problem, that may be enough to tell you I should really consider adopting a different mark. Has your search uncovered all possible problems? Well, probably not, because you probably didn't frame your search in the broadest way possible. But again, if your own search uncovers just one problem, that may be enough to tell you, I really think I should consider adopting a different mark. But again, to get a fuller picture, one of your options is hiring someone to do the search for you. Next. Now, the other thing to consider when you're adopting a mark is, are you adopting a mark that would be considered a strong mark? There's a whole spectrum of marks ranging from strong to weak. And if you have the opportunity at the outset to adopt a mark that is strong, that's what you should do. So the spectrum ranges from, as you see here, fanciful, arbitrary, suggestive, descriptive, or generic. Let's go through examples of each of these. Next. So a fanciful mark would be something like XEROX or Kodak. Those words never existed in our language until someone said, I'm going to put these letters together to form a brand new word that I want to be a source identifier for my goods or services. Again, source identifier, trademark. They are specifically formed for that purpose, so they are as strong as possible. An arbitrary mark would be something like Apple for computers. Apple, obviously a real word in the dictionary, but the relationship between the word and the product computers is totally arbitrary. We consider that to be a very strong mark. Suggestive, here we have copper tone for suntan lotion. That mark, copper tone, suggests that if you use that product, your skin will turn a beautiful copper tone. You're still okay because you haven't gone to the level of descriptive. Here is where you start to get in trouble. An example would be creamy for yogurt. That simply tells you the consistency of the product. Descriptive marks are difficult to register. They are difficult to protect, not impossible, but difficult. And so if you know that you might have a problem, you're better off adopting a mark that at least gets to the level of suggestive, or even better, arbitrary or fanciful. Now, the last listing there, generic, well, this would be something like milk for a dairy-based beverage, where it simply is telling you exactly what the product is. A generic mark is never going to be registrable. Now, someone usually said, oh, well, I know what you're talking about. This would be something like Kleenex. No, Kleenex is actually still a registered mark. The proper usage is a Kleenex brand facial tissue, where the generic terminology there is facial tissue, but the trademark usage is is Kleenex brand. Now, most people know enough not to adopt a generic mark at the outset, but it is through misuse over time that a good trademark can actually slide into the generic category. For example, escalator, aspirin, zipper, thermos, at one point, those were all registered marks in the US, but again, through misuse, they slid into the generic category. So you always want to be careful that you are using your trademark in the manner of an adjective rather than a noun, rather than a thing. If it's a thing, then it's going to be considered generic. If it's being used as an adjective, again, such as Kleenex brand, then it will be functioning in the manner of a trademark. Next. So once you've done your homework, your legwork, and you think that you've come up with a mark that is going to avoid a likelihood of confusion, it's going to be a strong trademark, then we hope that you will file to seek federal registration. So this is our next topic, filing and registration. Next. So if you're filing for federal registration, well, the first step is going to be creating a USPTO.gov account. And that's a two-step process. We want to make sure that the person indicating that they are the proper filer is, in fact, the proper filer. So we require now an actual authentication. And once you have your account set up, then you're going to be filing through, as listed here, the Trademark Electronic Application System. Be aware that electronic filing is now mandatory except in very rare situations. Now, people always at the beginning want to know, well, how much is this going to cost me? Well, we base the fee on a little formula. The first part of the formula is the actual dollar amount. So it's listed here, either TEAS Plus or TEAS Standard. The dollar amount for TEAS Plus is $225, and for TEAS Standard is $275. Well, how do they differ? For a TEAS Plus filing, you're filing a very complete application. And the most important point is that your identification of goods or services, which is a required piece of the application, is taken directly from our manual of acceptable identifications of goods and services. When that application comes in as a TEAS Plus filing, the examining attorney immediately knows, because of how the wording is displayed in the application, that you have taken your listing directly from the manual. It takes about 2 seconds for the examining attorney to review that portion of the application. And because he or she is doing less work, well, less work, we pass those savings on to you. So the TEAS Plus has the lower dollar amount of $225. But perhaps your product is so new that it does not appear in the manual. Well, as such, you would not be able to use TEAS Plus. Instead, you would have to use TEAS Standard, where you would be entering a free text identification. So that's the first part of the formula. The second part of the formula is mathematically times the number of international classes listed in the application. Well, what do I mean by that? Well, all goods and services are placed in one of 45 international classes. Now, don't get excited that you're hearing the word international. Again, this process only gives rights in the 50 US states and our US territories. The reason that we use the word international is because the entire world uses the same classification. So, for example, computers are in class 9 and shirts are in class 25. So you only have one trademark, but you're using it in 2 different classes. So under that scenario, for example, filing under TEAS Plus, it would be $225 times 2, because you have 2 classes. Now you might be thinking, well, gee, wait a minute. I have pants, shirts, shoes, hats, jackets. I'm already up to times 5. This is getting expensive. No, all of those goods are clothing items, and they all fall within the same class. So it doesn't matter whether you have 1 item or 1,000 items. If within the same class, it is only times 1. Next. Now, another consideration will be how you display your mark within the application. And there are different possibilities here. Again, this is not how you are actually using the mark, but it's how you're going to apply to seek registration. So the first option is using the standard character display, which is basically a straightforward, you are typing the wording within the application. Standard character says, I'm not really concerned about the manner of display, the font, the style. I simply want to protect this wording. This option gives you the most flexibility. For example, this week you could start out thinking, you know, I want to give my business a very classic old world feel. So I'm going to use a display in the old English typeface. Next week, you may realize, that just makes my business look old and tired. I need something contemporary. So I'm going to start using it in the Arial font. You're permitted to do so because, again, under the standard character format, you are not locked in to any particular display. Now, it may be that your manner of display is very important to you. So you could, in fact, file under the special form. Again, familiar with the Coca-Cola wording there? We almost know it's Coca-Cola by the way the lettering swoops around to make a distinct impression. Now, if your mark consists of both wording and a design, well, one of the considerations is coloration. You actually are allowed to file in black and white. Again, this gives you more flexibility. Let's say you start out this week, you're displaying the mark in yellow and green. Next week, you realize, I actually hate yellow and green. I want to switch to red and blue. You're allowed to do that because, again, filing in black and white gives you that flexibility. The final example there, if you think, well, the coloration red and blue is very integral to my commercial impression, well, you could actually file in color. However, you are then locked in to that particular colorization. Next. Now, another requirement in the application is you're going to have to tell us exactly what your goods and services are. Now, one of the things you want to make sure you're doing is using terminology that is broadly understood, yet it is accurate, because you can never expand beyond the scope after you file. So if you're using TEAS Plus, you want to make sure when you're looking in the identification manual that you are selecting something that truly corresponds to your actual use. You don't want to, in order to try to save some money, simply adopt something that is close. Close doesn't count here. Again, it has to be accurate. Again, going back to that notion of not expanding the scope, this is why you want to be very careful. So let's say that you actually are using your mark with pants and shirts, but you're doing the application too quickly and you only list pants. And after filing, you realize, oh, I just made a mistake. You're not going to be able to come back to the USPTO and said, actually, I need to add shirts to my application. Unfortunately, you cannot expand the scope. You also are going to have a basis for filing, and there are two options here. You may already be using the mark in commerce, and that is commerce between at least two states or between the United States and another country. If you're filing based on actual use, at the time of filing, you're going to have to provide a specimen. What is a specimen? Well, it's simply a sample of how you're using the mark. For example, it could be that you display the mark on a label or a hang tag if your mark is used with goods, or let's say you have services, perhaps you upload a digital image of your storefront. Your other filing option is to file under the intent to use basis, and this is when you have a good faith intent to use the mark in the future. Because you're not using the mark yet, you can't provide a specimen. It's only later on in the process when you start using the mark that you'll be required to submit the specimen or perhaps an extension request. How does this work? Well, because your mark is not being used, it's not on the registration pathway. So instead of our issuing a notice of registration, we issue what is called a notice of allowance. And from the time the notice of allowance issues, you have 6 months to begin using the mark to request that we review the specimen that you have filed. Or if you're not yet using the mark, again, that's when you request an extension. Every 6 months, there's the same deadline. Either submit a specimen or submit an extension request, up through 5 possible extensions. At the 36-month point, there is no 6th extension. You must be able to show that you're actually using the mark. And if not, unfortunately, you have to begin the entire application process over from the very, very beginning. Next. Now, be aware when you file your application that all information within your application is going to become public information. We emphasize this because, unfortunately, there is a whole cottage industry that has sprung up using your information to send you misleading notices. And they're misleading because they often require fees that simply are not required by the USPTO. An example here, if you would see something coming to you from Patent and Trademark Office, Washington, D.C., you may very well be scammed into thinking this is a payment that I have to make. Well, again, the official office is United States Patent and Trademark Office, and we're based in Alexandria, Virginia. Anything that's coming from the official USPTO, if it's coming via paper, although again, most things today are coming electronically, but if coming on paper, it's going to be coming from Alexandria. And if coming electronically, it'll be from @uspto.gov. On our website as listed there, we have an example of all of the solicitations that we're aware of. We always say, please ask first, do not pay first. Always call the USPTO and say, I've received this, is it official if you have any question? Because unfortunately, the USPTO has no affiliation with these different groups sending out these solicitations. And as such, we will not be able to help you get your money back. So be very, very careful with this. Next. Now, this slide lists all the common bases for refusal. Again, remember that registration is not guaranteed. So you want to make sure that you're avoiding all the possible problems listed here. We've discussed likelihood of confusion, merely descriptive. The surname. Well, some people say, well, wait a minute. I see other surnames registered. For example, McDonald's is obviously registered. Well, McDonald's is registered because although initially refused as a surname, they were able to establish that over time the mark had acquired distinctiveness. So that's why they were able to register under a particular provision of our statute. Could also be geographically descriptive of the place where you're in business. The next one, very important to be aware of this because it's a very common problem where someone will come up with a slogan and say, you know, I'm going to put this slogan on the front of a t-shirt. Well, unfortunately, use on the front of a t-shirt is considered merely ornamental. It doesn't serve the function of identifying the source of the goods. So, for example, if you see a t-shirt with "Have a nice day" on the front of it, well, you simply acknowledge that, yes, they're saying "Have a nice day." It's not telling me who is the actual source for that particular item. And the last thing, we're going to look at the specimen to make sure that, in fact, it does demonstrate use with the particular items that you've listed in the application. Next. Now, what happens at the point of registration? Well, be aware that the USPTO, we simply do not have any enforcement powers, and it's up to you as the owner of the mark to try to enforce your rights. Well, how are you going to do that? Well, one of the options is, if you're aware of anyone who is infringing, is to send out a cease and desist letter. That's basically a way of saying, stop it, stop using your mark because we believe it infringes our mark. And you can use your registration certificate as an underlying basis to support the claim that you're making within the cease and desist letter. I would say you need to view the registration that's listed here as a sword, not a shield. What do I mean by that? Well, a lot of people make the mistake of thinking, well, I have my registration, so now I can just sit back and no one is going to attempt to infringe because they're going to be aware of the registration. Well, unfortunately, a lot of people try to infringe. They try to build on your goodwill by stealing use of your mark. This is why we say you have to step up to the plate and enforce your mark. Use your registration as a sword. Don't simply sit back and think, well, it's simply a shield to protect me. Next. Now, unlike patents and copyrights, which are only good for a set number of years, a trademark can last forever. In fact, we have some marks on a register that have been on a register now for over 150 years. But in order to keep your registration live, there are responsibilities that you have to step up and take, namely doing filings between the 5th and 6th year after the registration date to show that you're still using the mark that's known as the Section 8 declaration. At that point, after 5 years of continuous use, you may also want to do an optional Section 15 filing. This is to claim that your mark has become incontestable. What does that mean? Well, it's incontestable in the fact that no one can now challenge it to try to cancel. If you're successful in establishing incontestability, then your mark can stay live forever. Again, as long as you do the next step between the 9th and 10th year, you have to do another filing where you're going to request renewal in conjunction with the same demonstration as before, showing that you're still using the mark. That's known as combined Section 8 and 9. Now, we want to help you with this by emailing you a reminder notice. On the first day of the 5th year period, the first day of the 9th year period, and the first day of any 10-year period thereafter, we're going to send you an email that says, heads up, it's now time for you to do another filing if you want to keep your registration alive. So please make sure that you're keeping your email address current so we can get that helpful email reminder notice to you. If it changes, go onto the website and use the change of correspondence address form to keep that address up to date. Next. Now, finally, we want to discuss how can you find help? And there are several different avenues open to you. Next. Well, obviously, the main consideration for the USPTO is our website. There's the address, uspto.gov, and we have several resources there. We have the listed booklet in PDF form. We found that a lot of people actually don't want to bother reading a booklet, so we have almost all of the same information available in various video formats as listed there. And again, just take the time, sit down, watch a video. They're very, very helpful. Next. We also sponsor the Law School Clinic Certification Program, where law students under the tutelage of a faculty advisor are going to be able to work with you. Currently, we have 59 schools that are participating in this program. To find out if there is a law school in your area, go to, again, the front page of the USPTO website and use that upper right-hand corner, there's a search box. Use that terminology there, Law School Clinic Certification Program. That will bring up a page with a chart that lists all of the law schools that are participants in this program. And again, there might be one in your area that would be able to help you. Next. Another one of our resources is the Trademark Assistance Center, and the phone contact, the email contact is as listed there. Always remember, though, that the USPTO, we're not able to provide legal advice. We're not able to help you in any way to enforce your rights, and we simply cannot recommend a specific outside attorney to you. So please don't call up to the Assistance Center and say, this is the mark that I'm thinking of adopting, is it registrable? Well, that requires a legal opinion, and as such, that's not something that we're going to be able to provide any information on. We simply can try to point you in the direction of other tools where you could do research to make the determination yourself. Next. There are also throughout the country what is known as the Patent and Trademark Resource Centers. This is a nationwide network. So again, to find out if there is a PTRC in your particular area, use our website, search tool, enter PTRC, and that will show you all the PTRCs, their locations, and contact information. Finally, it's listed here. And again, I thank the host of this program, the SBDC, a very valuable resource available to you. So it's necessary, please use their resources. Next. Always remember, though, that the best possible resource for you may be an experienced trademark attorney. And you can do a search that's listed here. One of the good resources is the American Bar Association. We have a final warning there. Be very careful about using a filing company. You may be familiar with some of these, LegalZoom, for example, or Trademarkia. They do exactly that. They file your application based on the information that you provide. They usually don't step up and say, well, you probably shouldn't file this application because your mark is merely descriptive. Well, if that's the case, then probably you won't file and they won't get a fee payment. So be very careful about using one of those, because as listed there, they don't necessarily add any value. You could simply use the T system to file your own application if that's all you're going to do, is provide information for someone else to basically do the exact same thing that you could do. Next. Then there are free or reduced fee legal services, because I'm very aware that when you're starting out, any amount of money that you could save is helpful to you. So take advantage of the ABA, or as listed there, INTA. They do have pro bono programs that may benefit you. Next. And we're at the point that we've left enough time for questions, so please start asking and I'll do my best to answer.
Okay, we have the first question. Is trademarking a certification a different or unique process?
There is a subclass of trademarks known as a certification mark, where you're actually separately certifying something, but usually unless you fall within that particular category, you're going to simply be doing the more higher level trademark or service mark. But yes, there is a certain type of mark known specifically as a certification mark. So you should do more research if you think you fall within that particular designation.
All right, thank you. So we have another question related to service marks. Using storefront, what if you move?
If you move to a different location, you're potentially going to have an issue later on when you go to file that Section 8, only in terms of you're not going to be able to use the same specimen that you used at the time of your initial application, because now your storefront is different. We need to see how you're currently using the mark, but it's simply a matter of you're going to take another digital image of that new storefront, and with that Section 8 filing, that is the specimen that you're going to upload.
All right. The next one, if you don't sell a product outside of a state, should you seek a registered trademark?
Again, the requirement is that you're engaged in interstate commerce, and that's simply between, at a minimum, between two states. If you are only engaged in local commerce, then you're only eligible for a state registration. That may be the case, but it's very unusual in today's marketplace that you're so localized that you don't have any interstate use at all, or you don't have a website. But at the end of the day, that is the requirement. So be aware of that, that if you don't engage in interstate commerce, then you would only be able to do a state trademark.
All right. The next one, how do I monitor and find out if there's a new mark that is similar to my registered trade or my registered mark?
Well, you have two options there. On, let's say, a weekly basis, you would have to be going into tests. Again, that's the search system, and you would have to perform a search to see if anything recently has been filed. Or you could hire, there are companies that are monitoring companies. Of course, you would have to pay a fee for that, but that is their job. They monitor to see if any new application has been filed. They make you aware of that, and then you can decide what to do after that. So again, two options there, either doing it on your own or hire someone to do that search for you.
All right. The next, do I need to file as both a word mark and a special form mark, or do so separately?
Well, those are considered to be different types of marks. So you have to make a business decision, because obviously if you're filing two applications, that's going to be more expensive. So if your main consideration is simply protecting wording, then you would want to use just that standard character format. But if it also includes a design element that is very integral to your overall commercial impression, then you have to go with that other composite mark. The other thing I want to highlight is be very careful. Again, when you file, you're locked into that particular mark. So if later you think, well, actually my mark is not fancy enough, I want to add a design to it, that definitely requires a new application. You can't come back to us and say, well, this was my original filing, but now I have a new element, so please update my mark. No, we can't do that. It requires a brand new application.
All right. Is there any kind of monthly fee to keep your mark?
No, there's not. There is simply the initial application fee. And then again, depending on your basis of filing, if you filed based on intent to use, there will be additional fees, but there's not simply some sort of, as the questioner asked, some sort of monthly fee to keep your application or registration alive. Again, it's only after registration that there are additional fees falling between the 5th and 6th year, 9th and 10th, and every 10 year thereafter, again, to keep your registration on our register.
All right. How do I place the SM mark on my logo and website?
There's no specific place where it has to go. Usually it is in the upper right or the lower right. It's really your preference there. And again, it's not even mandatory that you use that, but it's a good thing to do, again, to put the public on notice that you're claiming ownership.
Is it possible to use a trademark to claim a social media account or domain name if someone else is using them?
Could you repeat that question, please?
Sure. Is it possible to use a trademark to claim a social media account or domain name if someone else is using them?
Well, two different things there. Again, remember that domain names and trademarks simply are different. I'm not sure if the question is going to, if I'm aware that someone has it as a domain name, can I use the same wording for a trademark? Remember that those are different processes, that the domain name goes through a domain name registrar. The only thing that they look at is whether there is identical wording being used as a domain name, whereas under trademark law, we are looking to see if there is any confusing similarity. Now, sometimes this goes to, well, I'm aware that, we'll just hypothetically say, Coca-Cola does not have their domain registered. There's no domain coca-cola.com. And as such, I'm going to try to adopt that as my domain. Well, you'll still hear from Coca-Cola. You cannot try to take someone's registered mark and stick it into a domain. That's simply going to be problematic to the owner of that mark, even though it does not come up in the context of a domain issue. It's still considered to be infringement, taking someone's mark and sticking it into a domain.
All right. If a trademark has been abandoned and dead since April 2015, can I apply for the trademark name?
Okay, so in our database, there is what is known as a status indicator. You're going to see either live or dead. An examining attorney may only use as a basis for refusal under the concept of a likelihood of confusion a mark that is live in the database. So if it is dead, even though it's on the register, it is not usable as a basis for refusal. However, you always have to be careful to find out, why is the mark dead? It may be dead because the applicant or the registrant simply missed a statutory deadline. If the deadline is missed, then registration has, the process for registration has to stop, or otherwise, if it's already registered, the registered mark will be canceled. However, it is possible that the owner of that mark is still using the mark in commerce, and as such has common law rights. So you could apply and again still get a cease and desist letter based on that claim of superior common law rights. So be very careful. It won't be refused within examination because it is dead, but it still is potentially a problem for you. Do some more research.
Are there any special considerations for nonprofit organizations or different requirements?
No, the requirements and the considerations are exactly the same, whether it is a for-profit or a nonprofit.
All right. Is a maker's mark, jewelry maker, a different type of trademark?
No, it is not. In fact, that's one of the earliest types of marks that we've ever seen, going back historically, that the maker of jewelry would want to make sure that the public would know it was coming from that source. So although it's being called a maker's mark there, it is in fact a trademark, and it functions in the same way.
How can I find out when the common law trademark started to be used?
Well, again, I termed that earlier as being a detective. You're going to have to, try to use the internet to find out when the product was first sold or when the store first opened. There's no easy way to find that out, except trying to do research through the internet for that purpose.
Can I use trade TM on my doing business as name versus my LLC business name?
No, if it's only being used as a business name in conjunction with the LLC listing, then again, that's separate and apart from trademark use. You have to be able to show that you're actually using it in the manner of a mark to be a source identifier for it to be appropriate to use the TM or SM designation therewith.
All right. And would there be any advantage to copyright the logo and register it as a trademark and service mark?
Okay, well, that's a different consideration. If you have a logo, the artwork itself, because it's an original artistic creation, that falls under copyright, and that's within the auspices of the U.S. Copyright Office, part of the Library of Congress. So that's the copyright portion of that, just protecting the artwork. And then the trademark consideration is if that particular logo is being used as the source identifier for specific goods or services, then that's when it moves into the trademark or service mark realm.
All right. I think that's it for the questions that are more sort of for the group. There's a couple more, and if you have any other questions, you can reach out and we'll answer those. Are there any other questions that people have to put in the Q&A box? Before we finish up, we have a few more minutes. If not, let's see. All right, I think. Any other questions? All right, let's see.
I can go ahead and close out, Amanda.
Okay, I did. Oh, I got just one more.
Oh, yeah, sure.
Yeah, could you maybe touch just briefly again on copyright info versus trademark? Kind of the.
Okay, so again, first going back to the definition for the copyright, it protects an original artistic or literary creation. So usually if you're trying to sort out, well, gee, I have this logo. So the logo, because an artist, whether that's yourself or someone that you hired to design that logo, that is considered an original artistic creation. So if you're wanting to protect the artwork, that is done through copyright, okay? But copyright only looks at the artwork. It is not looking, for example, how is the mark being used? How is that logo being used? When we're looking at that, that's when we're looking at the trademark consideration. So if the logo is being used as the source identifier, it appears on a hang tag or a label, for example, to promote the sale of, let's say, shirts and pants, then that is when you would consider seeking registration as a trademark, because again, it's serving that function.
All right. We have one more. If you receive a cease and desist letter, do you need to notify the USPTO?
No, the USPTO is not involved in that process in any way, because that is two outside parties who now have a dispute. So that is not something that the USPTO is involved with at all. Our role is simply determining whether any applied for mark is eligible for registration, not getting involved in a conflict based on the issuance of a cease and desist letter.
All right. I think we have one more. How long does the process take? I think, I don't know if that's.
Okay, so the application process, when you file your application, it's going to sit in queue for approximately 3 to 4 months. Why is that? Well, we receive over 700,000 applications a year. We just have to take the time to work through them. So initially it sits in queue, then it's reviewed by the examining attorney. If filed based under the use in commerce provision, then the overall process usually takes about a year, because usually there's some back and forth with the examining attorney, registration issues in about a year. Again, if you filed under intent to use, well, it's going to be a longer process, because we're going to issue that notice of allowance. Then the ball is with you. So depending when you start using the mark, it could be relatively soon, or if you go through all 5 possible extensions, well, that extends the process out to about 4 years, which is good because you were protected back when you filed that intent to use application, but we can't issue the registration until you show actual use. But during that period, maybe you're still trying to get your financing, maybe a factory to make your product. So that's why the intent to use filing is very helpful. But we don't know exactly how long it will take, because we don't know for sure when you're going to start actually using the mark.
All right.
Great.
Thank you so much.
Yeah.
Go ahead,
Thank you,
Deanna.
Craig. I think we'll go ahead and wrap up. I did put an email in there, help@virginiaspdc.org. You can ask questions there. I also had answered a couple of you, the Trademark Assistance Center at USPTO.gov. I'll send out all these links in our follow-up email, and send out the emails to you guys as well, so you will have all of that information. Thank you, Craig. That was awesome. I did also put in 2 surveys for you guys to fill out in the chat window. I will send that out in the email as well, so you'll have those links. And you can find out more information about other upcoming training sessions that we have going on in the state at virginiaspdc.org. Also on the website, you can find the Business Recovery webpage, which we developed to help owners continue business operations during this challenging time. These detailed guidelines cover a broad range of critical considerations, ranging from safety and workplace guidance to financial assessments and marketing and communications. While you can use them by themselves, they were designed to be used in collaboration with a business consultant at your local small business development center. And we have offices located throughout the state to assist you. Thank you so much, everyone. And thank you, Craig. We really appreciate all the time you spent here and answered so many of the questions. And we hope to see everyone at our next session. Thank you so much.
Thank you very much, SBDC. Stay safe, everyone.